Welcome to Maynooth University to this special event on rule of law within the European Union. I'm John O'Brennan, the director of the Maynooth Centre for European and Eurasian Studies. We're delighted to co-host this event with our colleagues from the newly formed Centre for European Law, headed by Professor Tobias and the Maynooth University Social Sciences Institute. This is the last event in a three-year cycle of events for a Jean Monnet Centre of Excellence project that we've been running that focused a lot on rule of law issues and on Central and Southeastern Europe. So I think it's very appropriate that we have somebody who has contributed enormously to public knowledge about this field. And I think it's fair to say has moved the dial on rule of law issues in Brussels and in national capitals. So it's a great pleasure to be able to welcome our guest speaker, Professor Laurent Pech. Laurent is a household name in this field internationally. He was previously a professor at Middlesex University and head of the School of Law there. Before that, he had worked at Galway University and has been appointed the Dean of Law, the head of the Sutherland Law School at UCD, and of course he is a full professor there. He's also a visiting professor at Bordeaux University and was one of the founding members of the Good Lobby Profs, one of the most active organizations in publicizing issues around the rule of law in Europe in recent years. So we're delighted to welcome Laurent back to Maynooth. He's been here a number of times before, and I'm very much looking forward to his contribution. It's also a pleasure to welcome my colleague, Professor Tobias from the School of Law in the School of Law and Criminology in Maynooth University. Tobias is also the Jean Monnet Chair in EU Law and Fundamental Rights. He previously worked at Edinburgh University as a senior lecturer, at University College London, Surrey University, and at Erlangen University in Germany. He specializes in European law and human rights law. He's particularly interested in the interaction between different legal orders. And as you can see, that's one of the key issues here that we're talking about when we're talking about the rule of law within the European Union. So a great pleasure to welcome Laurent. He's going to speak for 35 to 40 minutes or so. Tobias is then going to respond to him, and then we'll have time for questions and answers. And that includes questions from our colleagues joining us online. If you have a question, you can put that into the Q&A function, and we will be able to direct those questions to our speakers. But for now, Laurent, I'll hand over to you. Thank you very much.
Thank you very much. It's a pleasure to be back here. I'm afraid tonight is not going to be very an uplifting talk, because I'm going to talk about what I view as something rather depressing from a lawyer's point of view. I'm going to tell you about all the rule of law was dismantled in a number of EU member states and what the EU has done or not done or should have done since what has been called the rule of law crisis in the EU began, and we're talking about 2010. So this rule of law crisis, in fact, has been going on for more than 10 years at this stage. A lot of damage has been done, as you will see. And I'm going to offer you a rather critical overview of the situation, not because I have anything against the EU institutions as such, but I'm going to sound perhaps excessively critical, but because I think the criticism is warranted in this case. And I will show you why, and then obviously you can ask me questions, and I will see whether Tobias does agree with me or not. As a good lawyer, however, I'm going to begin with essentially a basic legal provision, and then we're going to move from this basic legal provision to essentially what is rule of law backsliding, and then the kind of the key tools which could be used or have been used or have not been used or have been misused by the EU institutions in terms of dealing with what I have called rule of law backsliding. It's impossible for me to be very exhaustive in this context because, as you will see, in fact, a lot has been going on either in the, mostly actually in a negative way. And in terms of case law, now the situation in 2023 is radically different when I started working on actually this topic. Once upon a time, it was actually a boring issue. I've been working on rule of law issues since the start of my legal career, and we're talking about 25 years ago. And I was one of the few working on what you're going to see behind me, which is Article 2 TEU. And when I started working on the rule of law issues within the EU, I was applying for jobs at the same time. And once I applied for a professorship, and I was turned down for the professorship based mostly on my research agenda. And the feedback I got was, great academic credentials, but the research agenda is rather dull. In fact, the rule of law, there's nothing to be left to say about it. Rule of law is very nice and all is well in the best of all worlds as far as the EU is concerned. So I was told, in fact, there is no need for me to focus on the internal situation when it comes to the rule of law, and I should, in fact, focus on respect for the rule of law in EU external relations. So that was the feedback a long time ago. Now, sadly, Article 2 TEU should not be a topic of controversy, but he has become one. Article 2 TEU, so TEU stands for Treaty on the European Union. The EU is based on two founding treaties. The TEU is one of them, where you find the key constitutional principles on which the EU is based. And Article 2 TEU is known for those working on the rule of law and other foundational values of the EU. This Article 2 was not part of the original package from the 1950s. In fact, if you look at the founding treaties of what we used to call the European Economic Community, the rule of law concept was not mentioned as such, but it's not because the EU from the early days was not based on the rule of law. It's just the concept was not as dominant in political debate as it became following the fall of the Berlin Wall. However, the concept was implicit in many provisions of EU law. But the explanation actually is simply that British lawyers were not involved in the drafting of the EEC. It was mostly German and French lawyers. And we use different concepts to refer to the English rule of law. But leaving this historical footnote aside, Article 2 TEU was part of the EU treaties since the early 1990s. It was just to symbolize the key foundations on which the EU system is based. And this is very consensual at the time, following the Berlin Wall. All the international organizations started emphasizing compliance with the rule of law, not only as a key constitutional norm within the legal system, but also as a key external value. Article 2 TEU that you see behind me initially only mentioned three key values: the rule of law, respect for human rights and democracy, and then we added some additional values at the time of the Lisbon Treaty. And for a long time, Article 2 TEU, no one really was paying attention to it until some of the values you can see mentioned in this treaty provision started becoming challenged or undermined by some member states, some of which I will mention later. But those undermining the rule of law, just to focus on the rule of law, started to argue that since the rule of law is not defined in the treaty provision you see behind me, in fact, it's not a legal concept that you can use to enforce in legal terms. The argument was it's an open-ended concept, it's a political concept, and in fact, it's a meaningless concept. So I'm just summarizing kind of the arguments from the autocratic governments violating the rule of law. And they were, in fact, they went as far as denying, in fact, any competence. The argument is not only is the rule of law meaningless, but in fact, EU law does not define the rule of law, so the EU institution cannot even enforce the rule of law. And if they were to enforce rule of law standards, they'd be acting beyond the powers allocated to them. All of these arguments became part of a legal action recently, just to very summarize this historical overview. Last year, yes. Sorry, it's been a long day, forgive me. Last year, the Court of Justice issued two very important judgments, the key leading judgments on Article 2 and the meaning of the rule of law as per Article 2 TEU. So I have summarized kind of the key findings from these two judgments. So I don't know if we have lawyers in this room, or even if you're not a lawyer, the two case numbers you can see mentioned behind me are the two most important judgments regarding the meaning and the scope of the rule of law in EU law. So if you are working on these issues, this should be your starting point. The two judgments are quite long, and it's about conditionality regulation, which I'm going to mention. It's about a new instrument which was adopted by the EU in 2020 and has been used against Hungary to suspend EU funding on rule of law grounds. It's a bit technical, but essentially, this is not the point I'm trying to make at this stage. This is where the Court of Justice answers all these conceptual arguments that the rule of law is not a legal value, doesn't bring any legal obligations. Long story short, every single counter-argument raised by the Polish and Hungarian governments was rejected rightly, in my view, by the Court of Justice. It was, in a way, a bit kind of historically important. It was the first time in the history of EU law that two national governments actually challenged the rule of law as a legal concept. It never in the history of the EU we had seen two governments formally denying that the rule of law is a legal concept and also denying the power of the EU to enforce compliance with the rule of law, even though respect for the rule of law has been always a membership condition. So you cannot join the EU technically if you don't comply, among other things, with the rule of law. And the rule of law, in fact, has been defined in many pieces of EU law. So the argument that the rule of law in EU law is open-ended has always been, in fact, misleading. There was no definition of the rule of law in the TEU or the other treaty, but that's nothing unusual. If you look at national constitutions mentioning the rule of law is never defined, with one exception, arguably the Spanish constitution, but that's the exception. The norm is the key values on which a constitutional system is based normally and never defined in constitution. This is not the place where you define all the concepts. If you start defining every single concept you see mentioned in the treaties, then the treaty will be 3,000 pages long. An example I often use when I get this argument about the rule of law not being defined in the treaties, especially from the soon-to-be previous Polish government, I tell them the concept of EU worker is not defined in the treaties. Are you denying that there should be EU law regarding free movement of workers? So, I mean, I can easily multiply arguments or explain why this is just a silly point. Rejected by the Court of Justice. And perhaps a last remark regarding these two judgments of the Court of Justice. The Court of Justice used a verb which it had never used before, the verb defend. The EU has a duty to defend EU values when these values are undermined or under threat at member state level, or even you could argue at EU level when an EU institution itself would act in violation of the rule of law. So in fact, this is a clear signal from the Court of Justice that not only does the EU have the power to enforce rule of law compliance, but there is a positive duty to actually act when the rule of law is under a systemic threat or is systematically violated in a member state. So essentially at this stage, what we can already agree, I mean, you may disagree with the judgments of the Court of Justice, but it's completely legally inaccurate to argue that the rule of law is not defined in EU law and that the rule of law in EU law is not a legal concept which cannot be enforced by EU institutions. This is legally wrong, has been established by the Court of Justice. So the two Polish and Hungarian governments lost the case. And in fact, the Hungarian government then became the first country to be subject to the regulation they challenged. But before I get back to this regulation, I'm just going to explain now what is rule of law backsliding. And rule of law backsliding was something actually defined. So this is kind of my definition with Professor Scheppele from Princeton. We wrote an article together and we thought it'd be helpful to define what we mean by rule of law backsliding. What we describe, even though we use the concept rule of law, but you could also accurately describe this process as democratic and rule of law backsliding. Usually, it begins with essentially, just to oversimplify, this is a process whereby newly elected government is going to engineer the top-down dismantlement of all the national checks and balances. So we're talking about a deliberate undermining of the rule of law. So essentially, in practical terms, what we're talking about, you have a new elected government and they don't want to do the next elections. And they have essentially usually 5 years to dismantle all the checks and balances. And by the time they're done, then essentially the country is no longer a rule of law democratic system, but essentially an hybrid regime, if not a fully authoritarian regime. And the first victims of rule of law backsliding, which is a process, so whereby you dismantle deliberately in a methodical way all the checks and balances, but the first target is usually always the top courts of the relevant legal system. So they always start with prosecutors and judges. I tend to distinguish between primary targets of and secondary target when you're finding yourself in a country subject to rule of law backsliding. Primary targets tend to be the media, judges, prosecutors, and the police. And then once they're done, then they move to secondary targets, taxation administration, NGOs, academics, lawyers, students, women, minorities. But essentially, I don't have time to do this, but it's actually what we have learned, at least what I have learned, is that it's surprisingly easy to actually dismantle checks and balances, actually without paying any price, meaningful price from the EU quickly enough. And in fact, also in terms of dismantling checks and balances, either you do it legally in one way or another, or you do it illegally. So if you do it illegally, then it's even faster. But the long story short is actually there is a blueprint, a playbook you can use, and has been used, in fact, by autocrats worldwide. They tend to learn from one another. So best practices travel, but worst practices also travel. And in fact, there is such a thing which has been called the autocratic playbook. So I have written about the autocratic playbook, and in fact, I could be hired by a would-be autocrat, and it wouldn't take me much time to advise them on how to dismantle the rule of law in the country. In fact, we have a live example now, Slovakia. It's happening live. So they're doing the autocratic playbook in a high-speed version of it, at least. And I would say within 12 months, then you can end up with another kind of a hybrid regime within the EU. The rule of law backsliding, to summarize, it's a process whereby essentially you deliberately, newly elected ruling coalition is going to engineer the dismantlement of all checks and balances. And he has a strong rule of law component to the extent that judicial independence is going to be one of the first objectives. Undermining judicial independence, replacing independent judges with cronies, or what I call fake judges. How many examples of backsliding countries do we have in the EU? Sadly, we have quite a few now. In 2010, essentially, backsliding began in Hungary under Orban when he was re-elected. Having lost once, Orban then spent a lot of time studying other systems, such as Turkey or Venezuela, to make sure that he would never lose power should he be re-elected again. And so I don't have time to really explain the autocratic revolution from a legal point of view, which happened in Hungary. But within 3 or 4 years, essentially, Hungary stopped being a democracy. So Hungary could be described, I tend to describe Hungary as Exhibit A when it comes to rule of law backsliding in the EU. Poland then kind of follows suit. And in fact, the supreme leader of the previous departing ruling coalition, he said something very famous. He said famously that if he gets re-elected, he will make sure that we will have Budapest and Warsaw. That's the expression he used. So it kind of, some advisors went to Hungary, learn how to learn about the autocratic playbook and what to do should they be re-elected. And the Polish authorities, however, as you will see, became essentially the subject of some action by the EU institutions, which reacted very quickly, by contrast to the lack of reaction to the situation in Hungary. Having learned essentially a bit more about what I have described as rule of law backsliding, something nothing to be proud of, but by 2020, according to the data you see behind me, according to a Swedish research institute publishing an annual report known as the Annual Democracy Report, this Swedish institute is known as the VDEM Institute, the Varieties of Democracies. They publish an annual report where essentially they look at what they call the autocratizing countries, so backsliding, aka autocratization. And they have a ranking of the most backsliding countries in the world. And then they also have a better ranking of those democratizing the quickest in the world. In 2020, so if you use 2010 as a point of reference and 2020 as the end point, the worst backsliders in the world were Poland ahead of Hungary. In the case of Hungary, the backsliding has gone for so long that they decide to downgrade Hungary, no longer considered a democracy, but an electoral autocracy, which is a political science concept to describe a country where essentially you have a de facto one-state party, but with some regular elections, largely free, but structurally unfair, meaning that the ruling party, it's almost impossible to lose the elections unless they're really trying very hard to lose it because the system has been structurally rigged way ahead of the election. So it doesn't matter if you have free elections because essentially you have no freedom of information, no freedom of association, no judicial independence. And if something goes wrong as well, you have changed the judges anyway, so you can always not recognize the elections. So long story short, we have some of the worst backsliding countries in the world still are Poland and Hungary. And sadly, the situation became even worse last year. According to the same research institute, they identify an additional number of countries which are engaged in a backsliding pattern. One of which I can mention, perhaps surprisingly, when I tell people, Greece was the top autocratizing member state according to this research institute, if you take the last 3 years as your point of reference. Backsliding country doesn't mean the country automatically becomes or ceases to be a democracy. It just means it's a... And the end of the pattern essentially is that if you are a consolidated democracy, you may end up being a consolidated autocratic regime at the end of it. So sadly, backsliding, rule of law backsliding still happening in the EU. And even though in terms of intensity, Hungary and Poland are in a different league from the rest. And I would say on current, because of the recent elections, now you could expect backsliding to stop, but reversing backsliding is actually a lot of work, legally very demanding and technical, so quite challenged. But I'm not going to address reversing or restoring rule of law in the backsliding, post-backsliding. It'd be a different, you can invite me again. So what I'm going to tell you now is about essentially EU's action or inaction. Now, there are different forms of action and different forms of inactions. I cannot give you the full spectrum tonight. So I'm just going to show you some of the main forms of action / inaction. And you're going to see it's a kind of, you have about 10 shades of action and 10 shades of inaction. And action can be good, but also action can be bad. And I'm going to give you an example of good action and several examples of actually something worse than inaction, negative action, making the situation worse by actually acting. Because sometimes people think simply in terms of EU's inaction, but sadly, in the past few years, actually, we have seen examples of the EU making it worse by siding with those undermining the rule of law for a number of reasons. So this is not meant to be exhaustive. So I'm just going to review some of the rule of law instruments during the course of this presentation. And just to oversimplify what we had initially after the rule of law crisis began, we had facade of action, so facade of action. I'm not sure how to say this French word correctly in English, but facade of action would be the right pronunciation.
Your French is terrible.
And that has been a source of criticism for me, because essentially in post-2010 until 2016, 17, we've seen a lot of pretense of acting. And there are different versions of this. One version was, instead of acting, you would pretend to act by spending a lot of time discussing tools and adopting new tools. One of the key arguments used by EU institutions to justify the kind of a lack of success in terms of containing rule of law backsliding, one of the recurrent excuses, actually, you can see still it mentioned these days, we don't have the right toolbox. So that's just driving me nuts at this stage after 10 years of hearing this. And that was the dominant kind of a song in those days. I mean, we would love to kind of contain or at least stop backsliding in Hungary, but we don't have the right tools. And for the first, from 2010 to 2015 in Hungary, apart from a few infringement actions and some strong political statements, nothing was done in terms of, and this is why essentially by now essentially it's possible, the situation in Hungary cannot be salvaged because it's no longer a democracy, it's a consolidated authoritarian regime. Anyway, now some examples of facade of action, I can multiply them very easily. But let's say instead of acting, instead of enforcing rule of law requirements, the EU Commission and the EU Council started adopting new instruments, one of which was known as the Rule of Law Framework in 2014. So that was the Commission's baby. And then the same year, the Council adopted the annual Rule of Law Dialogue. But all of these new tools are largely toothless. Why? Because they are based on a dialogue with the relevant member state. And those undermining the rule of law, I mean, they're not going to be scared by a dialogue-based process because they know exactly what they're trying to achieve. And in fact, a dialogue-based process is ideal for them because they can just pretend. So you're pretending to act, the EU, and then the rogue state is going to pretend to be interested in a dialogue. Meanwhile, the rule of law is dismantled in a practical sense. You have independent judges fired, replaced by so-called new judges. And then essentially nothing happens on the ground. You just have this dialogue-based process with no legally binding consequences whatsoever, even if the dialogue leads to no results. So for a few years, a lot of time was wasted building new tools and implementing the wrong tools. These new tools, which are mostly based on a discursive approach. The discursive approach doesn't work with those undermining the rule of law because they know exactly what they know, what they're doing. And they know exactly that time is of the essence. So you need to undermine, dismantle, destroy the rule of law as quickly as possible, because by the time the rule of law requirements may be enforced, then there's nothing to be saved. So that's an example of, so the rule of law framework I've just mentioned was used against Poland in 2016, but for 2 years, essentially no enforcement. 2016, 17, just more dialogue. The Council is even worse than the Commission when it comes to facade of action. So even though I'm being more critical of the Commission than the Council, it's because the Commission is supposed to be the guardian of the treaties for the students of EU law, and the Commission is supposed to act and react when EU law is violated, especially in a systemic manner. So this is why I tend to spend a lot of time criticizing the Commission, because the Commission has the tools actually to react. The latest kind of I don't want to be mean and sound like I'm only spending my time criticizing, but we have the latest tool, which is mostly kind of an information gathering tool. We have an annual rule of law mechanism now, and every year the Commission publishes a rule of law report. So you have a transversal rule of law report and also country chapters. So they are very interesting. So you get kind of a 12-month overview of the rule of law situation in all the countries. But this doesn't help those, again, this doesn't help in relation to those undermining the rule of law and wishing, knowing that what they have in mind is an authoritarian regime in practice. Last year, these country chapters included some recommendations, but if you violate the recommendation, again, no direct legal consequences. So kind of it gives a sense that the Commission is really taking the rule of law seriously, but it's just more reports. And if the recommendations from the reports are not complied with, then there are no direct legal actions. And there are a lot of other systemic, structural, conceptual, and normative problems with these rule of law reports. Is that the reports may or may not be accurate, may or not reflect what needs to be reflected. Just to give you an example, which I found completely mind-blowing. The rule of law reports now include information on non-compliance with judgments of the European Court of Human Rights, which is not an EU court, but we don't have data on non-compliance with the judgments of the EU court. So we have an EU report about the rule of law, paying more attention to the non-compliance. Very important. I suggested to do both, actually. But then why don't they include data on non-compliance with ECJ judgment? Because if they do, then people are going to say, where is the legal action? Because they have the legal tools to sue a member state. So that's why I think it's also difficult to gather the data, but I think there is also a legal consequence if you formalize, if you attest, or if you are of the view that there is non-compliance. So essentially, there's been a lot of time, if you don't mind me saying so, wasted on creating new tools, complaining about the lack of kind of an ineffective toolbox. This was quite convenient for both the Commission and the Council, because it was buying them time and then still projecting an image of actually taking the rule of law crisis seriously. Another one, moreover, this time, so it's not facade of action, it's procrastination mode or complete inaction, in fact, regarding Article 7 TEU. So there is another treaty provision I didn't mention, but essentially, long story short, this is an exceptional mechanism provided for in the treaties to eventually suspend the voting rights of a member state in a situation where the member state is systematically violating the EU values to be found in Article 2. This Article 7 was nicknamed rather wrongly the nuclear option in EU law. So kind of an option you don't want to use, which explains also why it was not used when it should have been used. So it was used for the first time in December 2017 in respect of Poland. But the Commission has always refused to use it in respect of Hungary, forcing the Parliament to actually activate the same mechanism. but not the sanctioning branch of the mechanism in September 2018. This Article 7 has not produced expected results, but my diagnosis is that there's nothing wrong with Article 7. It's just everything which is wrong is actually by those using Article 7. So initially we had a lot of procrastination from the Commission. The Commission did finally use this instrument, but then only to see inaction regarding Hungary. And then when both Hungary and Poland were subject to the Council's scrutiny, then the Council decided to self-sabotage, at least that's my assessment, by essentially adopting the worst possible interpretation of how to make this procedure work in practice. The Article 7 itself is very short, so the Council had to adopt rules of procedure, so how to operationalize this. And they have organized the procedure in the most ineffective possible way. So I can multiply concrete examples, but I don't have the time to do so. But essentially, we are now in 2023. We have 2 parallel Article 7 proceedings still ongoing, and nothing has been achieved. Nothing has been done by the Council, apart from a few hearings. And then I could go on about in terms of being critical. Now, for EU lawyers or EU law students in this room, you must be familiar with infringement actions. This is a very old mechanism allowing the Commission to sue member states when they violate EU law. And strangely enough, this is an instrument very well established. The Commission refused to use until 2018, after essentially 8 years of rule of law backsliding, which is a bit, I mean, to protect the rule of law. The Commission does use infringement actions regularly, but I'm talking about in a rule of law backsliding context. And to make it worse, they have been in denial, at least the public position of the Commission is that in fact they are making a very active use of their infringement powers, but that's not true. In fact, there is a very good, amazing, eye-opening article by 2 US professors, which are mentioned on the slide, Professor Kellerman and Pavone. And the data you see is actually from their article. They show that the Commission essentially stopped enforcing EU law at the same time that rule of law backsliding was gaining speed. So that's the worst possible time to actually stop using infringement actions, or at least reduce the number of infringement actions you bring to the attention of the Court of Justice. So there are a number of reasons, mostly political reasons, explaining why the Commission decided to stop its using legal powers to enforce EU law. And certainly you cannot argue that there is more compliance with EU law obligation now or in the last 10 years than there was in the 1980s or the 1990s. In terms of rule of law, actually, in terms of data, it's very easy because there are not so many infringement actions. To deal with rule of law backsliding, we have a total of 5 infringement actions in total. All of them concerning Poland, with the 5th one pending before the Court of Justice. My assessment, very briefly, is that all of these infringement actions are very welcome, but they came in too late and not with the right scope. By the time they were scoring a victory in the Luxembourg court, and then a lot of irreparable damage was done to the Polish judiciary. I can further justify this diagnosis, but quite clearly there is an issue with the Commission refusing to enforce EU law the same way it was enforcing EU law until the last few years. So something happened, something in terms, you need a political scientist to explain this better than me. But essentially, the guardian of the treaty, essentially my diagnosis has stopped seeing itself as the guardian of the treaty, and this was the worst possible time to stop enforcing the EU law, including EU rule of law obligation through this traditional instrument. When in fact, there was no need to invent new tools. You could have used this from the start and we'll be in a much better place. And that's also my claim. Now I'm going to tell you about something which is worse than inaction, which is actually complicity with those undermining the rule of law and essentially using the rule of law as a bargaining chip for a number of non-legal reasons. There is the case of Poland recovery plan. Full disclosure, I've been very active in terms of preventing Polish recovery money from being disbursed to the Polish government. And in fact, I'm part of the team of legal advisors who essentially have been helping European judges sue the Commission, the Council and the Commission. You see on the slide, so you have kind of an excerpt from the press release of the Commission. And then on the other side of the slide, you have kind of the headline from an article about the lawsuits we lodged with the EU General Court at the time. But essentially, long story short, my argument is that the Commission in this time did something worse than inaction. Actually, for geopolitical reasons, mostly, they decided to make money accessible to the Polish government, but to get in the process, they agreed a deal. Just to oversimplify, to get access to recovery money, the Commission can impose a number of so-called milestones. In the case of Poland, they imposed a number of rule of law milestones. The problem, according to us, at least some of us, some of these milestones actually directly violate the case law of the Court of Justice. So essentially, they made access to EU recovery money way too easy and essentially became complicit in co-organizing, or at least making it possible to violate ECJ rule of law judgments and still gain access to EU money. So the cases are pending. We'll see if we're going to be proven right. It's a bit difficult in terms of for technical reasons, but I think it was the right thing symbolically, if anything. On the substance, I would say we would win if we are given legal standing. In fact, there was just between us and those watching online, there was a judgment of the Court of Justice in July, kind of agreeing with all submissions before the EU General Court. So our main issue is no longer the substance. I'm pretty sure we would win on the substance. The main issue is whether we can have legal standing recognized by the EU General Court. That does raise a number of technical issues I don't have time to explore. But the main point I'm making here is that sometimes there's something worse than inaction. It's actually treating compliance with the rule of law as something you can play with for political reasons. There is additional examples of what I believe are something which is worse than inaction. Here, I'm talking about Romania. I know perhaps time is flying, so I have to be relatively quick. But this is an additional example of the Commission essentially looking the other way, and in fact, rewarding in one way, I would argue, those who have undermined the rule of law or do not want to actually remedy existing rule of law violations. So essentially, I'm talking about here Romania and Bulgaria. Recently, special mechanism was essentially ended. And to justify the end of this mechanism, essentially a number of legal arguments were made, but I would argue these legal arguments are misleading or even very partial. In the case of Romania, the Constitutional Court of this country has been actively violating the rule of law judgments of the Court of Justice. How many infringement actions by the Commission regarding these straightforward, very serious violations of the judgments of the Court of Justice? Not a single one. And the Commission has ended the mechanism just when the Court of Justice actually explained that this mechanism was producing legal effects. So essentially, not only did the Commission not react to these violations of the rule of law, they have misused an instrument which could have been better used to actually protect the rule of law since 2007. So it's actually even worse when you take a look at this from a long-term perspective. And this is my last example of what I call worse than inaction mode. So this is happening as we speak now. So essentially, before I get to the worse than inaction mode, actually, this is a good, so I have a positive example of meaningful action, finally, at long last. This winter, for a number of legal and political and geopolitical reasons, the Commission and the Council finally, for the very first time after 10 years of rule of law crisis and systemic, straightforward, blatant violations of the rule of law, they acted and meaningfully using the financial card, suspending not only money going to or pre-allocated to Hungary, but also money allocated to Poland under several headings. We're talking about a serious amount of money in both cases, considering the country's GDP. In the case of Poland, we're talking about a total of 75 billion euros, so a very large amount of money. And for Hungary, now about 30 billion, but under different headings. On the slide here, you're looking essentially at what was done in terms of cohesion funding. Hungary was subject to rule of law conditionality regulation. So as we have seen, 6 billion euros suspended. They have yet to be given access to EU recovery money. So that's another, I think, but 12, yeah.
14.
And then also the Commission actually, and that surprised me. I didn't expect the Commission to be bold, and I did welcome this boldness. The Commission suspended cohesion funding and the different other different legal under different legal basis. But essentially, this was the first time we've seen meaningful, proportionate reaction considering the threat and the violation of the rule of law. Now, the problem is whether the EU Commission and the Council are going to stay the course, and it looks like they won't. It's not yet certain what's going to happen over the course of the next few weeks. But what I'm reading in the press is actually very worrying. There is some people pushing within the Commission and within the Council. Actually, an important point. Even though I criticize the Commission and the Council, they are not monolithic institutions. There is a lot of divisions, dissensus within both institutions. But I have to oversimplify, if only because of time constraint. Now, but this is very important. This could be, if this goes ahead and the EU does unlock access to EU funding because of the extortion tactics employed by the Hungarian government. Essentially, the Hungarian government is saying, we're going to veto money to Ukraine unless you give us some of the money which is currently suspended. And we don't care the way you do this. We just want what they call all money. But if the Commission looks the other way, it's going to have to formalize this. And looking the other way on political grounds, that would be a straightforward violation of different provisions of EU law, but that would be essentially a clear abuse, if not misuse of powers, which can be legally challenged if you have legal standing. Sadly, again, natural and legal persons do not have that legal standing, but the Parliament could. But essentially, this is again, it is as if they haven't learned from the past mistakes. Every time you reward this kind of extortion tactic, you're subjecting yourself, you can be sure that there'll be more extortion tactics being used against you. This is very unhealthy as a practice.
I should say that MEPs have been particularly vigorous, at least a subset of them, in keeping track of and publicizing these cases. And this morning in the European Parliament, while you were on your way here, I suspect Johannes Hahn, the commissioner, was asked about this, and he said, particularly about this article, we are not releasing the money to Hungary. He was very definitive.
Yes, I've been following this file long enough to know what's true on a Monday is not necessarily true on a Friday, and I've seen the misleading statements made to the Parliament before. So I wouldn't take this as face value. So count me skeptical at this stage. I hope this is correct, and this is clearly the right position. Meanwhile, just to show you the latest news in terms of what the Hungarian Prime Minister is doing, what you're looking at is technically, I mean, de facto is home, so place of residence, even though formally speaking, it is owned by his father. So we're talking about a 30 million estate. So which is difficult to see, or the Prime Minister of Hungary could afford this because his annual salary is 180K per year. And this is, even though this is a kind of a place of residence, now it's conducting official business in the estate. So that's why some questions are being now raised about who's funding this estate. In terms of data that you see on the slide, this is actually that's from another, I mean, I don't have to even, there is plenty of data regarding corruption and rule of law, but I thought it'd be interesting to show you some data or visualizing what is called regime corruption in this data set. So you have the EU average, and then you have the Hungarian average in terms of regime corruption. So but clearly you can see there was backslide. The rule of law backsliding always leads to more corruption, more institutionalized corruption and lack of enforcement, because at the same time that you are misusing or misappropriating EU and national funding, at the same time you have taken control of the prosecutor's office. So then you can use the prosecutors against EU enemies, domestic or otherwise. But also why is it worth sharing is because Hungary is now refusing to unlock funding to Ukraine on the basis that Ukraine is too corrupt. Let's look at the data first. And in fact, according to the same data set, Ukraine is less corrupt now than Hungary. So even from this specific point of view, the situation is not as described by the Hungarian Prime Minister. And very briefly, in terms of consequences, after 12 years of too little, too late action or inaction or facade of action, what's the situation in Hungary? At least one institution in the EU has accepted a very uncomfortable truth, which is that Hungary is no longer a democracy, no matter the definition you may have. Clearly, it's no longer a democratic system, even though you have regular elections, but regular elections don't make a country a democracy. Even dictatorships can organize elections, fake, rigged, or otherwise. But this is very important, formally speaking, because according to the treaty, there is a legal obligation for a national government to be democratically elected. Now, this is why the Council and the Commission have formally refused to endorse this diagnosis, because if they were to do so, then there would be a need for legal consequences. And you could technically legally challenge every decision adopted by the EU, which has been approved by a council decision, including the Hungarian government. But since no one has legal standing to sue on this basis, I mean, apart from the parliament, actually, this is not happening. But this is also important politically and symbolically speaking. On the slide also, you have the latest data from an annual rule of law index put together by the World Justice Project. And I thought it was quite striking to see that in terms of, there are several benchmarks to measure compliance with the rule of law. And when it comes to constraints on government, Hungary and Orban is very close to Putin's Russia. So something to meditate about. So and we're talking about a specific benchmark, which is essentially to what extent is the executive bound by rule of law constraints. And there are no constraints anymore on the executive power in Hungary. So it's kind of close to a proper consolidated authoritarian regime. When it comes to Poland, and that's my last slide, what are the consequences of this kind of a too little, too late action, even though there has been more enforcement actions and finally some financial sanctions, but only too late? Well, Poland is still a democracy, even though there was a clear worrying backsliding pattern, but they have undermined judicial independence in such a systemic way over so many years and in such an intense way that essentially there is not, for instance, almost every court, I mean, every court in Poland has irregularly appointed judges. Every single court is irregular, has an irregular composition, and this is especially impactful when it comes to the national courts of last resort. So the Supreme Court of Poland, the Constitutional Court of Poland, the Supreme Court of Poland, all include judges who cannot lawfully adjudicate as judges because they are not real judges. They were illegally appointed. This is create massive legal headaches because we have now more than 100,000 judgments which are not correct judgments. This is affecting the day-to-day livelihood of the Polish citizens. And this has starting to have dramatic consequences on Polish taxpayers also because more and more people are now bringing complaints to the European Court of Human Rights, so much so that the European Court of Human Rights has become worried, has expressed its worries of being essentially suffocated by the number of applications coming to its attention from Polish citizens. Why is it worrying from the point of view of the European Court of Human Rights and from the broader point of view of the Council of Europe? Because it is now established by the European Court of Human Rights that every single judgment involving an irregularly appointed judge from the top courts, from the apex courts in Poland, is automatically essentially a violation of the right to a fair trial before an independent court established by law. So you have potentially now on paper, you have thousands and thousands of judgments which are not compatible with the European Convention on Human Rights. And every single one of these judgments could be effectively challenged before the European Court of Human Rights, resulting not only obviously in financial losses from the taxpayers' point of view, but also, I mean, you can think of the dramatic consequences on natural and legal persons. So it's not simply about the rule of law. We're talking about every single subject matter regulated by law, which can be decided by an irregular judge. We're talking about family law. We're talking about taxation law. We're talking about public procurement. We're talking about employment. So every single sphere of Polish law has been essentially impacted by the increasing number of people pretending to be judges and pretending to be able to lawfully adjudicate. So at least this kind of issue should be possibly addressed now by the what we expect to be a new government in Poland soon. But this would not have happened if the EU had reacted more quickly and more meaningfully at this. That's my point. And here it's a good example of the consequences beyond the EU of EU's inaction. And I could go on, but I think you get the picture. And if you are interested in further reading, so I mean, and I'm happy for the slides, by the way, to be shared in one way or another. So these are my latest studies on rule of law, backsliding related issues. But if you're a lawyer now working on this or starting working on this, it's actually quite difficult because if only because of the sheer number of judgments. So thank you, Tobias. Happy to hear your comments.
Thank you. Thanks very much indeed, Laurent. A glimmer of light, you might argue, in the election of a new government potentially in Poland. But just as that happened a few days before that, we have the emergence of a new coalition in Slovakia, as Laurent said, and already within 10 days, it had started doing exactly the same things that Orbán did in 2010. And they potentially become an ally to replace Poland in the European Council on the Article 7 discussions. So, Tobias, over to you for your comments. Thank you very much.
Well, thank you. Thanks, Laurent, for this. I teach this. I've been teaching this subject for about 10 years now. And at the beginning, there was nothing to teach, right? I mean, there were two cases about age discrimination against Hungarian judges and something about media, very lame. And there was an elephant in the room and everybody knew it, but neither the court nor the commission mentioned the rule of law or anything like that. And now we've got this mushrooming of cases and complications in all sorts of ways, with all sorts of, these commission rule of law reports and things that are happening as well. So a lot of paper has been produced, but to little effect, it seems. Now, where do we start? I mean, I'm old enough to remember the EU's first rule of law crisis, which was actually in, around 2000 or so, when Austria got a new government and the far right was a junior partner. And all of a sudden, the other member states started boycotting Austria. So it was a fairly tame boycott. I mean, there were no group photos at council summits and all of that. But still, something happened. Everybody felt that that was worthwhile doing. And these bilateral sanctions, I mean, it just struck me today that it was probably the last time member states could agree on doing something, even though nothing had actually happened, really. I mean, it was not that the Austrian government, the new Austria, had started dismantling the rule of law in Austria. It's still reasonably well intact, I suppose. I don't know. I don't go there that much. But the last time I was there, it seemed all right. It seems as though the EU has not learned to grapple, or the EU law has not learned to grapple with rule of law crises. Yeah, so it seems the law seems to not be working, and EU law doesn't seem to be working, doesn't seem to be able to cope with mala fide interlocutors, with mala fide member states. A bona fide violations of EU law we can deal with. We have enforcement proceedings, we have preliminary rulings, and sooner or later the misapplication of EU law in the member state will stop. And that's how we've been operating for a very long time. But we can't seem to be able to deal with a member state that doesn't operate on a bona fide basis. Now, and obviously Article 7, which would be the reaction, hasn't been activated, and it's structurally now, it was for a long time structurally impossible to do so. You need unanimity in the European Council, and if you have two member states backing each other up, that's it. That's the end of the story. So a very, very difficult situation. Now, I would also like, but I was thinking, despite the gloom, which I share, overall, there have been some, perhaps, too much to say, positive developments. I'm not sure, but some developments anyway that I think could be seen to be positive. And I think the Court of Justice of the EU has tried to do things by, coming up with or presenting to the European Commission certain tools that they might be able to use, and by developing the law. So I think the first major development in the law was in the Portuguese judges case, where Court of Justice, I mean, it was completely unrelated to the rule of law, was a case concerning a financial hit that all civil servants in Portugal had to take, just like Irish civil servants after the financial crisis. And they said, well, that undermines our independence as judges if we are, sanctioned in terms of salary. The Court of Justice then said, well, it doesn't, but look here, you as national judges, you are judges that apply EU law on a daily basis. You're absolutely central to the enforcement of EU law, to the rule of law in the EU. And if judges are not independent, that means it's automatically a violation of the right to a fair trial, right to an effective remedy, which are all there in the Charter of Fundamental Rights and other sources of EU law. So that was, I think, an important judgment. And then the Commission took that and tried to bring enforcement proceedings, and the Court of Justice then went along with it. So, the Court of Justice presented them with, a key to some of the problems, perhaps. Now, obviously, these enforcement proceedings don't work because they take a long time and they only address punctual issues, small issues, that then the member state might say, oh yeah, we're going to change things, or we're just going to ignore it, and things keep deteriorating in the background. But there was something. I mean, also you mentioned, of course, that the Court of Justice now said, well, the values of the EU are justiciable. Article 2 is justiciable, which the Commission now has taken in a case that they brought against Hungary, I think, was it last December, about the anti-LGBT legislation that I think only this week, was it this week, that some museum director was suspended on that basis because they were showing, I don't know, gay propaganda.
Was that case not unique because there were also maybe a dozen member states that were part of bringing that case?
No, they joined as a
joint. They supported the Commission,
which is very unusual.
Yes.
By
the sheer number was the highest number ever. I think.
So that, I mean, but also, that case will be interesting, of course, but it'll also come too late to rescue the situation. What about the Polish elections now? If there will be a new government, that's still an if, right? Because obviously the president of Poland is from the other camp, and he's asked the current government to, try and form a future government, which they won't be able to do. But there are ways and means, if you're creative enough, to prevent a locally elected government from coming in. Just think about the American experience there. But even if they got in, and it's very, very difficult when you think about it to turn the clock back. Yes, there are certain things you can do. You can remove certain disciplinary procedures that are currently in place into the future. That's fine. But how do you deal with a court like the Constitutional Tribunal in Poland that has been appointed contrary to the rule of law? Do you dismiss the judges? Okay, you can do that. That would be the right thing to do. Okay. But what happens 5 years later when the old party comes back in? Will they say, oh, we're going to dismiss all the judges again because that's what the previous guys have done, And so you're back to square one, because one of the interesting things I always found about the rule of law deterioration in Hungary and Poland is that they never said we're about to dismantle the rule of law. They simply said, oh, we're just doing what other EU member states are doing as well. So when Hungary adopted its new constitution, when was it, 2012 or thereabouts, they said, oh yeah, well, we've got this distinction between things you can never change and things you can change, but that's what the Austrians have. So they just took the worst examples of constitutions, bits that don't work very well, or that are not optimal in certain member states. Appointment of the judiciary, for instance, they could point to Ireland. Who knows how the judiciary is appointed? Somebody taps somebody on the shoulder and then they're a judge. Well, it kind of works because everybody has a certain moral commitment to, the truth and the rule of law, dare I say, whatever it might be, and is it defined or not? But you can see that, and that might well happen again. Then in a future scenario, 5 years, 10 years from now, the other guys get back in. They might say, well, the previous government, nobody complained when they removed all the judges, so we can do it too. So how do you deal with this? It's very difficult to do it in practice. And obviously, now, I don't want to assume anything about Donald Tusk's integrity, but governments quite like power, right? It's in their nature. It's in the nature of executives to like power. And are you really going to restore all the things that make governing difficult? Just because they're nice. It's quite nice to be free as a government. And if you're doing the right thing, who would disagree? So I'm skeptical. I'll be interested to see and interesting to hear what Laurent has to say to these. How the backsliding can be reversed, if at all. And now, obviously, next steps will be, and we're obviously at the EU level, we're back to politics, right? And as we've seen, it's not in the forefront of politicians' minds. We've got so many crises going on: Ukraine, Middle East. There will be new ones in the future, and they might need those member states. They might need those member states, and so they will probably end up paying out money at some point in the future, perhaps. And things don't work. And obviously, the EU has its own rule of law struggles at times, not such dramatic ones, but there have been not everything is fine in the EU institutions or the way EU law works either. So it's not that they necessarily know exactly how to do things. Anyway, these are my comments. I don't want to keep anyone from too long. No, I know it is getting late, and I'd be interested to hear maybe what you might have to say about, especially the reversing the backsliding bit is very interesting.
Yeah, I can reply very quickly, and then I'd be happy to answer questions. So I would perhaps disagree slightly. In fact, EU law does provide all the tools you need to actually deal with backsliding. It's just the tools are not properly used. So I would say the problem is not EU law, the problem is EU institutions, and especially the Commission and the Council. And especially the Commission failing to act as I see it should be acting as guardian of the treaties. There's an aspect I didn't mention, but you rightly mentioned about essentially national judges asking the Court of Justice to protect the rule of law. And in fact, this is how we have obtained so many good judgments from the Court of Justice. But in fact, this is an indictment of the Commission's failure to act, forcing national judges and quite often leading these national judges to face either formal or informal reprisals. So they've been sanctioned, disciplined, suspended, family members threatened. So this is serious stuff. And in terms of data, 5 infringement actions to protect the rule of law in Poland, about 40 requests for preliminary ruling from Polish judges. And in fact, if you include all the national judges asking rule of law questions to the Court of Justice, and especially Romanian judges, been very active as well after Polish judges, we can go to a total of about 70 judgments, which are actually due to national judges being brave and asking questions, even though he may have a negative, in fact, he had negative impact on their professional and family life.
I remember also there was the Irish judge, Justice Donnelly, who refused to extradite a Polish national to Poland after a request from the Polish government, because she said she could no longer be sure that that person would get a fair trial.
Yes, and that led to a judgment. Actually, Court of Justice, to summarize, has been very good and strict in terms of rule of law compliance. But in this case, it wasn't, at least from my point of view. It's a bit complicated, but essentially the Court of Justice said you can only refuse the surrenders to Poland if you can prove that the person, so the rule of law, systemic violations of the rule of law, we have a direct impact on the actual case of the relevant person being surrendered, which is impossible to prove in practice.
Yeah.
So this is where the Court of Justice arguably did not go as, or didn't do what was required, but the Court of Justice, and in fact, if you have to summarize, I would say the Commission and the Council, not done enough, not even close.
Yep.
Parliament and the Court of Justice are the two key institutions which have been trying to essentially offset the lack of action, prompt action from the other two institutions. I would say, sadly, when it comes, so Parliament has been very vocal, very strong, very consistent but there's been a card which they haven't used at least often enough, so that legal action. The parliament has legal standing in any case, so can sue wherever. I cannot bring a case myself. And they've done so only in one important instance when the commission was refusing to activate the rule of law conditionality regulation, but after it had been activated, they withdrew the case. But let's say I told you about the Polish cases, the Polish recovery plan. So forcing Association of Judges brought annulment actions, which is actually quite a set of landmark applications. But that's exactly where the parliament should have sued, not forcing national judges and European judges and academics to sue. This was the job of an EU institution, but they didn't do it. Actually, they were about to do it, but there was just something which is not widely known. There was a vote in the parliament, and we lost the vote by 1 vote. And that is due to a Polish opposition MEP. So, but that's a problem. Also, the parliament is a political institution. So whenever they're thinking about legal actions, they're using not simply, obviously, legal considerations, but also political considerations, rightly or wrongly.
I'm going to come to questions now. I've been monitoring questions coming in online and people in the room as well. But I just want to look at this from a political perspective, if I could, for a moment, when we're looking at the future. One of the most depressing things about the current environment is that in 15 out of 27 member states, the far right is polling at 20% or above. In Austria, the Freedom Party is now polling at around 30% in advance of a general election. And at the other side of the Atlantic, the messages that are being received from the Trump campaign are that he thinks he was far too timid first time around, and that he is absolutely determined to smash the checks and balances that barely held up last time in 2020. So are we right to be depressed about the outlook for the rule of law on both sides of the Atlantic, conscious that we're coming into a European Parliament election in 2024, where all of those forces that I've talked about nationally are going to be very significant players, and where for the first time we may see a plurality of far-right MEPs, that is, the far-right composed currently of 2 groups, the ECR and Identity Europe, often don't get on with each other very well, but if they manage to coalesce, they may have more seats for the first time ever than the European People's Party or the centre-left Socialists and Democrats. So what is the outlook for the rule of law against that kind of political background?
I'm happy for Tobias to answer this difficult question. I would say, political. I'm a lawyer, so I don't tend to answer political questions. But as a lawyer, I can obviously pay attention to the political dynamics within the EU institutional framework. If there is, let's say, there is currently a pro-rule of law majority, to oversimplify, in the parliament. And this is very helpful in terms of obtaining evidence from other institutions. So, for instance, parliamentary questions, oral hearings, expert studies. If the parliament is lost to some extent, and the commission and the council do not seek to enforce compliance with the rule of law and the rule of law is violated, then you're left with the Court of Justice, but the Court of Justice can only get cases 2 ways, either from the commission to simplify, but then they will no longer get cases. And then, so you only then left with national judges sending questions. But then the first thing they do when you want to undermine the rule of law or create an autocracy, you go after the national judges. And in the case of Hungary, for instance, they don't even have to prohibit formally Hungarian judges from sending questions, because they have created enough of a climate of fear that essentially Hungarian judges have stopped doing so. And then you end up with a system in which the Court of Justice doesn't get any more cases when the rule of law is violated, because the rest of us, natural and legal persons, normally do not have legal standing. And then essentially you have then the perfect environment for the EU itself to become a more autocratizing organization, where essentially backsliding would no longer be the exception, but rather the normal and acceptable course of action in domestic politics.
Okay, I'm going to ask our audience whether you would like to put a question to Laurent or Tobias. Yes.
My question is, so my question is whether the EU bodies or even the member states have any tools against the Commission. Is that possible? Is the Commission can be held accountable and responsible for its kind of compliance and maybe for its non-role as guardian of the treaty?
For the failure to act.
Yes.
Yeah.
So yeah, very good question. Obviously the Parliament can, that's one of the main jobs of the European Parliament, to make sure that the Commission does comply with its obligations in terms of, and also in terms of legal actions. So in fact, the Parliament has been very, very critical of the lack of infringement actions, especially as regards Hungary and Poland. Another very good point raised by your question is, what are the other governments doing? So they are directly involved in so-called Article 7 proceedings. The Irish government has been very active in this framework. The Irish government is one of the few governments systematically asking good rule of law questions whenever the council does meet to see or discuss the situation in Poland and Hungary. However, the national governments have another legal tool which they have refused to use in a rule of law context. We tend to forget the national governments can bring infringement action themselves when the Commission doesn't do so. So there's nothing technically preventing, let's say, the Irish government from bringing an infringement case against Hungary or Poland or any other member states on rule of law ground.
Isn't it true that historically the member states have been reluctant to bring cases against each other? Sure. And there might be good reasons for that.
I mean, technically, that should be the exception rather than the norm. So that's the job of the guardian of the treaty. But there was almost a rule of law case which was due to be brought by the Dutch government against the so-called the muzzle law of Poland. And in fact, it was a very embarrassing moment. There was a majority vote in the Dutch parliament, essentially asking the Dutch government to look into an infringement action at the time where the Commission was refusing to do the job for a number of reasons. And this vote itself was quite groundbreaking. It was kind of the first time a parliament voted in favor of a rule of law infringement action to be done by the government. And it was politically very embarrassing because at the same time, the Commission was telling the European Parliament, we're doing the best we can in terms of rule of law enforcement. And you have a national parliament disagreeing with this. And then then there were Dutch elections. So essentially this infringement action never materialized, and the Commission soon afterwards anyway, finally lodged the infringement action. And in fact, in terms of infringement actions, again, we tend to blame the tools. Infringement action can be very quick. You don't need 12 months to put together an infringement action, especially when the rule of law violations are very straightforward and have been well documented. There's been one of the arguments of the Commission is that, I was criticized once, several times, in fact, saying that, you're a law professor, you live in your ivory tower, you don't know what it's like in the real world, blah, blah, blah. Infringement actions take time, blah, blah, blah. And then suddenly the council got excited about something, infringement action in a week.
Yep.
So whenever they want, they can get infringement actions very quickly. In the case of the UK, for instance, internal market bill, I don't know, like in the Brexit context, infringement action apparently can be done in 2 weeks or 4 weeks. And apparently in the rule of law area, it's just much more complicated when in fact there are no technical reasons for doing that. And there was a recent example, actually, the Commission reacting very quickly and strongly regarding the so-called less Tusk in Poland, where essentially they tried to undermine the free and fair elections by, long story short, but the Commission reacted, I would say perhaps within a week or two. And 3 or 4 years ago, what I was being told is we cannot do that. So apparently when there is a will, there is a legal way. So always kind of take always with a pinch of salt when you get essentially being told that you cannot meaningfully and quickly act because of legal obstacles.
Yeah.
When politicians tend to hide behind the law, it may or may not be always accurate.
Yeah. We have a question from Paulo Duver, who is one of our regular correspondents. Thank you, Paul. I'll bring them kind of together, but he's basically asking, is there a mechanism through which the European Union could eject a member? We have the famous Brexit article, and we found out how difficult it was to achieve even voluntary exit from the European Union. But has it reached the point where the member states really need to think about a mechanism through which they could expel a member state? And if so, how on earth might it be done legally?
So the short answer is no, you cannot expel a member state, even when the member state has stopped being a democracy or is engaged in systemic violations. At most, you can suspend the rogue member states from the decision-making processes. And then if we were to include an expulsion mechanism, then you would need unanimity because it would require treaty revision. So as long as you have a rogue state in the system, then this is kind of a blue sky thinking, which is not going to go anywhere. And my personal position, for what it's worth, is I'm against expelling a member state because quite often, in fact, in most cases, we're talking about a top-down dismantling of checks and balances against the majority views. So if you look at the polls in Hungary, for instance, the Hungarians, if anything, are asking for more EU actions and interventions to deal with corruption, to deal with undermining of judicial independence, to deal with unfair elections, to deal with attacks on journalists. So there is not a majority in Hungary, at least my understanding, in favor of Hungary becoming an authoritarian state. So you should not sanction a large segment of the population for the action of the government, and that would be disproportionate from my point of view to expel a member state. Mm-hmm. I would say we have a moral obligation as well towards the population in any member state when their government stops acting in compliance with Article 2 values.
There's a question from Alicia Fourage, and her question is really about how do we explain the inaction by the European Union, given that these abuses and transgressions are of such a serious order that they actually threaten the EU's legal order. How do we really explain, for example, a context where Hungary depends entirely on the European Union for its investment? 4% of its GDP comes in the form of direct EU subvention. So with all of that leverage that the European Union has, why hasn't it been more prepared to act, even where, for example, last week, Orban was in Moscow standing beside Putin?
So a very good question again. There are several explanations, so more of a kind of an institutional nature and then more of a political nature. So it's a mix. So there is not like a single transversal explanation to make sense of this kind of inaction over a long period of time. Initially, I think there was inaction because there was a lack of understanding of what we were dealing with. I remember going to Brussels, explaining what I have explained to you in terms of rural backsliding, and they say that's not true, it's not happening. Mm-hmm. And when I was describing the facts on the ground, they said, no, that cannot happen. So there was a denial because they could not cope with this happening in the EU because the assumption has always been that once you join the EU, essentially things are going to get better. Backsliding was just impossible for some people to cope with. Mm-hmm. So there was a bit of denial. There was a lack of understanding of what we were dealing with. Tobias mentioned a very important point. The EU institutional system is based on good faith actors. The EU institutional framework is a very highly consensual decision-making / institutional framework. And the assumption, the unwritten assumption that everyone is engaging in good faith. When you had bad faith to the system is struggling to respond. And then you have the DNA of the institutions in the council. It's a very diplomatic DNA. So there are cultural explanations as well. There's an inability to actually confront a peer government. Yeah. And then you have the broader political picture. And then, because it'd be too long for me to explain, but I can just refer to the best scholarship regarding this very issue. Mm-hmm. If you want to understand why this inaction from a broader political science point of view, I would say you have to read the scholarship of Professor Kellerman in the US, and he has coined the concept of authoritarian equilibrium. Mm-hmm. So he explains how different factors, mostly of a political, but also economic and a partisan nature, explains why the EU did not act or denied what was happening. Mm-hmm. An important factor in the case of Hungary, as John would know, is that Orban was part of the mainstream Christian Democrat Party, the EPP, the most powerful European political party, for a number of reasons. This membership protected, or at least dissuaded EU actors from meaningful and prompt enforcement.
Yeah.
I can multiply examples, actually even unknown examples, on how membership of the EPP directly resulted in legal inaction and the lack of financial sanctions.
Yeah. The Fidesz was a member of the EPP all through the years of Chancellor Merkel. To me, she was the worst German leader since 1949, and the damage done to the rule of law under her leadership, because she was effectively the leader of the centre-right in Europe to all that time, and they kept Fidesz in.
Mm-hmm.
It was completely inexplicable, in my view.
Yes, completely right. And in fact, I cannot prove it, but let's just say I have a lot of friends in a lot of EU institutions. And it wouldn't be unheard of for a head of state or government to actually ring the president of the commission and say, don't enforce the rule of law requirements because of broader political considerations. Mm-hmm. And if the head of government or state is from the same party as the president of the commission, you may well have a very receptive here.
Yeah.
And in terms of, and to come back to bad faith, actually, I just thought of a crazy example, a true example, but again, difficult to scientifically evidence because you wouldn't have access. The Hungarian government, to delay enforcement actions, or they used to send the wrong translations of Hungarian legislation to the commission services. So by the time they get the translation, the lawyers would see that there's something wrong. Then essentially you need more time to be spent on translating. And then we're talking about 4 or 5 months of just a kind of a bad faith undermining of the internal decision-making processes. The same bad faith can be seen in Article 7 hearings, where you have these two governments directly, bluntly lying to the other national ministers. I think in most cases, the other ministers know they are being lied to, and nothing is done for a number of political and cultural reasons.
There are a number of questions online that I'm going to bring together. One of them is there a political or legal strategy that can be employed by the average Hungarian citizen, for example, which might help to combat the backsliding observed in Hungary and elsewhere? And my colleague, Dr. Pauline Cullen, asks about civil society in Hungary and in Poland. The backsliding has closed down space for civil society, especially in Hungary. Arguably, the situation is much better in Poland and played a role in the mobilization of large numbers of people in the recent election. But what kind of role does civil society have as a kind of bulwark for cementing the rule of law or against these abuses when they emerge? And is there a link to the European Union in that sphere?
Again, very good set of points. NGOs, or civil society groups, are part of the secondary targets I have mentioned earlier during our presentation. Every would-be autocrat is going to adopt a legislation kind of based on Putin's legislation regarding NGOs, kind of a foreign agent type of legislation. Hungary did so. Polish government tried to do so, but it was a different legal framework. To be fair, the Commission did bring an enforcement action against the anti-NGO legislation of Hungary, but again, in a kind of a too little, too late fashion, and the Commission won. But so in Hungary, essentially, the civil society space has been completely shrunk. And whoever is left is being very brave, because you are harassed on a day-to-day basis. And they try to suffocate you either financially or through informal harassment tactics. They use kind of the taxation administration, especially, to make sure that essentially you don't have a viable, you're not viable. So essentially, if you are an NGO a member in this kind of a consolidated autocracy, essentially you kind of you have agreed to sacrifice your professional and personal life. So it's crucial that the NGO or the civil society groups get together in a very early stage of the backsliding process, rather than reacting when it's too late. In the case of Hungary, essentially also that there's another EU law aspect to it. In Hungary, EU free movement law has proved to be actually favorable to backsliding. Because what I mean by that, because of free movement rights, a lot of potentially people who could have fought against backsliding decided that they had enough. And in fact, there was huge migration from Hungary to other member states, especially I have many friends of mine who are professors, and they've decided that enough is enough. And you just have, at some point, you have to make a personal decision about what's best for your family when you work in a very consolidated country, a consolidated authoritarian regime. If you stay and you're being critical, you will be targeted and you will pay a significant price. It's not simply NGOs, anyone actually. Judges, prosecutors, civil servants. I forgot to mention this aspect, but one of the first also targets in Poland and Hungary was a mass purge of the senior echelons of the civil service. In the case of Hungary, I think we're talking about 3,000 to 4,000 civil servants who were purged, fired. So civil society, crucial, but better get together very quickly at an early stage. And what's the good news is that there is case law now on freedom of association. So the Commission has the legal ammunition to sue and bring infringement action as long as there is a will to do so.
Yes, Jane Babb asks again, what can we do as EU citizens to ensure prompt action is taken in relation to Slovakia? So some of what you've said there, I think, is
I would say also something people don't think about, just write to your MEP, raise the issue with your MEP, and then get this MEP to raise the issue in plenary sessions, ask written questions to the Commission, the Council, write to your government, say, why don't you raise this in the Council meeting? There's a lot which can be done in terms just of simply reaching out to your elected representatives, and the Irish MEPs, for the most part, have been quite good on the rule of law front.
Except for two of them, who I will not mention.
Thank you for your presentation and also for all the comments there in the top table. I just want to raise a little sort of light on this on the Irish side of things. Now, it's a little bit to one side of what you're saying, but I work for an association of municipalities in Ireland, so county and city councils. 2 weeks back in Strasbourg, where the Council of Europe delivered a very strong critique of Ireland's lack of adherence European Charter of Local Self-Government and the lack of subsidiarity and of autonomy for local government in Ireland. There's an index there as well, the Local Democracy Index. And on that one, of the 45 Council of Europe states, we rank at number 42, just above the aforementioned Hungary, Moldova, and Russia. Now, I accept it's a long way away from what you're saying there, but nonetheless, you mentioned quite rightly the European Parliament elections next year. On the same day, the Irish people will be elected 949 local representatives. So there's a little bit of backsliding on in an Irish context, and something that's going to be worth keeping an eye on. I can keep this report.
Sure. Position of local government in Ireland has always been very weak. It certainly hasn't got any better, and in some ways, it's actually got worse, with greater centralization of power at national level. But it is of a different scale to the things that we're talking about here.
That being said, there's nothing preventing you from raising this issue while when the Commission is compiling rule of law country chapters, there is kind of you have the chance to submit your own feedback, and you could argue. So then obviously the Commission is only going to be interested if you can show that local government legislation or structures are being used to undermine the rule of law, which is not the case in Ireland as far as I know. But I would agree that it could be a weak spot which could be exploited by an authoritarian central government. And in fact, in the case of Poland, what has saved the rule of law in Poland is the fact they had very strong decentralization of power, which meant that the national government couldn't undermine the rule of law as quickly as they were able to do in Hungary, where it was much more centralized. In fact, the more centralized the system, the easier it is for a would-be autocrat to undermine the rule of law. So strong local government is actually kind of a safeguard. So you better beef it up before you are in a backsliding situation. And I would say it's actually an important factor in terms of slowing down the backsliding process. So there were actually a few constitutional factors explaining why Poland was able to sustain or to resist backsliding for more effectively and over a longer period than in the case of Hungary. So you have it's very important to look at a system in the abstract and see potential weak spots which you can solidify or correct before what I would call an authoritarian takeover. If anything, slowing down backsliding is very important in terms of giving time for judges, prosecutors, law professors, lawyers, anyone essentially in favor of defending the rule of law to get together before it's kind of before each of us are taken apart by the new a new authoritarian government. So I would say I would not underemphasize the importance of local government.
No, absolutely. I mean, I'm it's bane of my life, the lack of local government in Ireland personally. But that is an aside. But I think the kind of separation of powers doesn't just work between the three branches of government; it also works vertically. And the more levels you have, it can be annoying at times because they don't get their act together. But it does contain power, and centralization tendencies are really problematic because we have overall worldwide, I think, a shift towards more executive power at the expense of the legislature and the checks and balances anyway. But one thing, maybe we should do this, or every member state should maybe have a rule of law or a democratic and rule of law backsliding audit every once in a while. And where are the weak spots? There's an interesting project going on at the moment. It's privately funded on a blog site in Germany called blog, which is quite well known Europe-wide. And it's about one German state which is the most likely to fall to the far right. And they've collected money, crowdfunded money to basically, run through a simulation of how the state could be captured. And it's very, very interesting. And I think something like that would be worthwhile carrying out in Ireland and other places as well.
And as a matter of fact, I did the first, what you're describing, I've called this rule of law stress testing of a national legal system. And I've done possibly the first study of a member state French government. So I did publish, it's a study only available in French. But if there is, or even for a student, it'd be very interesting as a research project or as an academic, as a research topic. You look at the Irish system overall, and you try to identify weak spots which could be used, abused, misused by a new authoritarian majority. And in fact, I mean, I'm not an expert on Irish constitutional law or the Irish legal system, but just as a non-expert, I can easily identify spots which could be easily exploited by a new authoritarian majority. Think about the judicial appointments. I know it's now being referred to the Supreme Court, but from my point of view, the current, I mean, to not have a judicial appointment commission is actually very dangerous because can be easily exploited, manipulated to actually appoint people who are there to implement a backsliding blueprint. So we need more safeguards, I would say.
We definitely need a mapping of the degrees of institutional resilience.
Exactly, that's the key word.
And the rule of law reports by the Commission are supposed to kind of function in that way.
But they don't do it.
They don't.
No,
they
they don't tell you what's the weak spots in your system. They just kind of an overview of the past 12 months. Some aspects need to be reformed, but they don't look at the structural design fault. To come back to a point made by John, actually, there is a major issue with the Commission. Either the Commission is a technocratic actor or is it a political actor? Now the Commission is more of a political than a guardian or technocratic actor. This has had a very negative impact on assessment of rule of law compliance. And in fact, we've seen in the case of Serbia, for instance, that the enlargement reports were actually overruled. The content of the rule of law section in the Serbian enlargement report, there was an attempt to doctor it. So with the Hungarian commissioner bullying the civil servants to pretend that the rule of law situation in Serbia was better than what it was. So it was only because it was leaked to the press by civil servants subject to the bullying and the harassment that essentially this was prevented. But I can also think of, regarding EU member states, I talked about the cooperation verification mechanism, and some of these reports,
which was applied to Romania and Bulgaria after they joined.
And there was a major serious issue about the content of the Bulgarian reports. I cannot prove this, but quite clearly from sitting afar, the reports regarding the situation in Bulgaria have nothing to do with the reality on the ground. And it has been suggested that this was a political decision, but never accepted as such for partisan reasons. Again, we have actually the EPP link here. So this is, I suppose the Commission is a bit now in a schizophrenic situation. Am I a political actor, or am I a technocratic actor? And this is why actually rule of law enforcement has become so ineffective. So how could I put it? So you can have the Commission acting as a guardian of the treaty on a Monday, and then acting as a political actor on a Tuesday, and there's a lack of consistency. You don't understand what's coming next. Are we going to stop enforcing the rule of law for political reason? And then suddenly, the following week, the Commission suddenly becomes very proactive in terms of enforcing the rule of law. What would be interesting is actually more research to be done regarding the internal divisions within the Commission. It has been brought to my attention that when it comes to rule of law enforcement, actually, the Commission has never been as divided as it is now, with essentially some different actors within the Commission, some very strongly in favor of enforcing, but then it's kind of a matter of negotiation. It depends on the file. So you have kind of almost political struggles within the Commission itself. And depending on who's going to come on top, you're going to have enforcement or you're not going to have enforcement. Yeah. But we don't quite know what's happening in the black box. So sure. So I tend to criticize the Commission as a kind of a single actor, but in fact, I know for a fact that it is strongly divided when it comes to the rule of law. Yeah. But it's important, I think, that's a little open secret I can share with you. This is why actually academics, experts are needed, because you'll be surprised essentially that, perhaps or not surprised to hear that whenever, let's say, people write about the rule of law and they complain about a lack of enforcement, this does provide ammunition, especially of a legal nature, which can be used internally by those in favor of enforcing. So it's not because you're not cited in official reports that you not have an impact, in fact, on decision-making process. And the Commission and also the Council of National Governments are very keen, strongly, always favorable to receive actually rule of law expertise and be able to access rule of law expertise on websites. So
I should say Verfassungsblog in particular has done a magnificent job over the last decade in making all of this accessible
and very quickly as well. So that's a quick legal reaction. So yes, it's actually the impact the Verfassungsblog has had on actual live decision-making processes has been huge. I know for a fact because civil servants tell me essentially, and sometimes also people ask me, can you write about this aspect? Because something bad is going to happen, and we need to have an expert advice which can be read by anyone. The problem is that actually the rule of law situation has gone from bad to worse, and even if I were working 24/7 on this, I couldn't cope. So this is why I created this network, the Good Lobby Professors. So I need to kind of revive this network because it's all of us working pro bono also, which the EU institutions don't have, I suppose, sufficient actually rule of law expertise. I mean, the Commission I criticize the Commission, but if you look at the numbers of lawyers working on infringement actions, it's just nowhere near enough. And there is no institutionalized network of experts. The Parliament has actually suggested that the EU should appoint an independent network of rule of law experts as well, but it'd be politically complicated. But essentially, I think it's important also for us. I mean, we cannot simply complain about rule of law violations. At some point, we have also to become agents of change, or actors as well. Even though when I do kind of take strong vocal positions against rule of law backsliding, then the criticism is that an academic is not supposed to do that. But I would say as lawyers, perhaps we have a special duty towards the rule of law. The lawyers, judges, law professors, I would say, in fact, I would even tell my law students, they have a moral obligation in their professional lives to actually defend and uphold the rule of law, not only in terms of their own values, but the day-to-day actions. And when the rule of law is under threat, I would say it is in fact a moral obligation for a law professor to go beyond the classroom and in fact to take a stand. But I would say this should be done carefully in exceptional situations. But then when you live in a democracy, you should cherish the democratic system in which you live. And if no one is doing it, then perhaps you should ask yourself, why not me? But that would be kind of a call for action for everyone in this room.
Okay, I think you've depressed us enough. Thank you, Professor Pech.
That was not my intention, but
I want to sincerely thank Laurent for that really, really illuminating exposition of the landscape around the rule of law. It brings together the legal and the political spheres. they exist either easily or more difficult in terrain, as you've clearly explicated. And I'm very, very grateful for you to have ranged over such an extraordinary terrain. So thanks very much indeed, Laurent. And thank you, Tobias, for really insightful responses to Laurent. Thanks everybody also who asked questions, whether online or here with us in Maynooth University. I also want to, in concluding, thank my colleague, Anne Hamilton-Black, who has been our technical savior on more than one occasion throughout this semester and this series of seminars and discussions that we've held. Thanks to Anne and her colleagues in the Maynooth University Social Science Institute. Thanks again to everybody for coming. Until we see you again, bye for now.